All right, thank you everybody for joining. We did not originally plan for a second session when I approached David, and he, graciously accepted to host our last session, which was to do with estate sales. But as the conversation flew, time got really, really short, and then we decided that a very valid topic would be wills associated with estate sales. And I mean, David Korman, we all know him, we all respect him, and he has so much information to give and such a wealth of information to share with us. So yes, David, I will let you go on with your presentation and enlighten us on this topic of wills. And I think we will touch a little bit back towards our original topic, which was estate sales as well. And we will open the forum for questions and answers towards the end of the session. So hold your thoughts, make the points, and we will for sure try to cover everybody's questions.
Okay, thanks, Sabiha, and thanks as always for your kind words, and thanks for having me back on. So this is really a continuation of, to some degree, of our discussion, with the last session, because we were talking about how you take title. And you take, and if it's the easy example is a married couple taking title to a real estate property and they own it as joint tenants. So just as a reminder, when you have that word joint in it, joint tenants means there's an automatic right of survivorship. So if one spouse passes away, the surviving spouse automatically owns the title to the property. So that was part of the discussion that we had in that webinar, because when the first spouse dies, the second one, if they held it, there's an automatic right of survivorship. They don't have to do anything. They don't need the will to transfer that to the spouse. And the same principle applies for any other property that's held on a joint basis. So we talked about that. It's a joint bank account, a joint investment account. When the first person dies, if things were held jointly, then whatever those assets were automatically go to the survivor. You don't need the will to transfer those assets. So that's part of what people do for estate planning purposes. It's good to own things jointly. It's good to designate a beneficiary in an investment account or a life insurance policy, because then you don't need the will to transfer those assets to the survivors. It happens automatically. So then the back half of that discussion is, okay, so what if you do need a will? So that's what we're going to talk about today. So let's say just in that example, husband and wife own certain assets. The husband dies. Like I said last time, husband always dies before the wife. It's a rule of law. So the husband dies, the wife gets things, whatever she gets by right of survivorship. But what happens then when the wife dies? Because now there is no right of survivorship. So now the wife would need a will, or the wife might need a will because maybe certain assets, or the husband's will might still be in play too, because maybe there were certain assets the husband owned that weren't held as joint tenants. So you need the will in order to transfer those assets. So bottom line is, I'll tell everybody that's watching, listening to this today, everybody needs a will. So when I get asked that question, and I get it from agents, I get it from other clients, I get it from everybody, do I need a will? The answer is always yes. You're always better off to have a will than not have a will. So we're going to go through a little bit of the process of what's normally included in a will. And I'll just remind you, that you should be thinking about this in terms of your own personal situation, your own family situation. Each one of you should have a will. Your spouse should have a will. Your adult kids should have a will. Your parents should have a will. Doesn't matter what the assets are. You're always better to have one than not have one. Okay. And basically, because if you don't have a will, and someone dies and there are any assets to be transferred, you have to go to court to give someone the authority to deal with those assets. It's an extremely expensive process, thousands of dollars. It could be contested. There can be more than one person that wants to control the estate, that wants to apply to become the estate trustee. So that could be a contested thing, when if you just had a will, you name who's going to look after your estate. It's up to you as an individual to decide who's going to look after it. It's up to you as an individual. It's your right It's a personal right. Each individual is allowed to say, when I die, who gets my assets? Who gets it? Who shares in it? If you don't designate that, then whoever you know in the world could apply to be a beneficiary under your estate. And then you have competing interests. And then they have to go to court, and they're going to spend thousands, and could be $50,000, $100,000 in court costs to try and sort out, who's entitled to that. So, and it doesn't really matter the size of the estate. It's anything. You can't upon your death, you can't transfer assets that you own to somebody unless there's either a will, or if there's no will, somebody gets a court order that says who gets what. So there's not a good reason to not have a will. Okay. The other thing you should know, when you make a will, a lot of people get bogged down in thinking, oh, I got to make a will, but I'm not organized. I don't know what all my assets are. I don't know what my debts are. I don't know what my liabilities are. I got to get organized first before I make a will. But the good answer that you should be happy to hear is, no, that's not correct. You don't need to be organized. And none of us are as organized as we'd like to be about our affairs. But the good news is you don't have to be to make a will, because the will doesn't specify, most wills do not specify particular assets going to particular person. A will for most of the population, a basic will, basically says, when I die, whatever I happen to own on the date of my death, this is who I want it to go to. And it can be in percentages, it could be, there's different ways to describe that. So in the simple example of a husband and wife who have kids who might be, young kids, or they can be married kids, a simple will might say, when I die, if my wife's alive, I want everything to go to my wife. And I'm not specifying what it is that I own. It's, you got to figure out at the time of death what I happen to own. But whatever it is, I want it to go to my wife. If she's not alive, then I want it to go to my children, divided equally amongst them. If and you don't even name the children, because God forbid something could happen to one or more of the children. You don't necessarily even have to name the children. You might have 2 young kids. Maybe you're going to have a third. Maybe you're going to have a fourth. So it just says, however many kids are alive of mine at the time of my death, they're going to share in it equally, or they're going to share in it unequally, whatever you decide you want to do. It's a personal decision. Okay. If it happens to be minors that are your children are minors when they inherit it, then there's things we have to deal with in a will about that as well. But that's basically how the way a will works. It's, when I die, whatever I happen to own that day, this is who I want it to go to. Okay. And you just specify that. The other point I want to make before I get into the actual slide presentation here is that a will is a very personal thing. There's no such thing as making a joint will. You and your spouse make a will together. Each person has their own will. Now, a lot of times we have a married couple come to us together, and we're getting instructions together, and they're making reciprocal wills that mirror each other, and that's fine, but each one gets their own will. Okay, it's a very personal thing. And just, I know a lot of you deal with power of attorneys, and we're going to talk about power of attorneys a little bit as well. And and the power of attorney for property, which is a power of attorney for signing documents, is a very powerful document. You can give someone during your lifetime, I can give someone the authority to sign any documents on my behalf. I can make it specific for a particular transaction, or I can make it general. They can sign any documents on my behalf. The one document that someone would not be allowed to sign on your behalf is a will. Okay, so because a will is a very personal item, it can only be signed by the individual who's making the will. Nobody can sign it on their behalf. It can't be done by power of attorney. So I want to get into this now. And I'm starting with the signing of the wills as opposed to what's going to go into the wills. And the reason I want to start with this, because a lot of people think, okay, I should get a will done. You might hear it from your clients as well. You're thinking to yourself, I know there's online will kits you can do, and there's things you can do online, and we should go that route. I'm not saying they're completely not good, because there are certain online versions that might work for a very limited amount of people. And there's issues with them, but they might be valid. But I caution you to just be careful, because there's 2 things that are really important to making sure a will is valid and can be binding and can be enforceable. And one is making sure the content of the will is correct and accurate and reflects what the party making the will wants it to say. But the other part is the will has to be signed properly, and it has to be witnessed properly by people qualified to be a witness. And the qualification of witness isn't that difficult. It's basically people that aren't named in the will. And it doesn't have to be a lawyer. Anybody can be a witness to the will, but it has to be witnessed properly, and it has to be initialed, and each page of the will has to be initialed by the witnesses. And you need 2 witnesses, and you need the person making the will, who's the testator, signing and initialing each page and signing on the signing page. And the other thing that's really important is the witnesses have to sign an affidavit as well, that they were together and both present, and they have to swear to this, that they saw the testator signing the will and they were together. If it was me and Sabiha were the witnesses, I'd be signing a declaration, an affidavit saying that I and together with Sabiha, we both witnessed, David Gorski signing his will, and we're signing an affidavit to that effect. And we need that. That's a really important document, because when someone dies, we need the original will with all the original signatures and the original initials. That has to be submitted to the court office, and that affidavit, at least of one of the witnesses, has to be submitted to the court office as well. And if you don't have that, you got a big problem, and you're back to going to court to get a court order to prove the will was valid and validly signed, et cetera. And it's a very expensive process. So signing wills is really important, which is one of the reasons why you got to be really careful if you're trying to do one of these online kits or will kits, because even some of them that I've looked at that are pretty good in content, you can get a will drafted properly up to a point, because then there's certain things that they can't do because they can't give you legal advice online. So there's certain elements that they can do a very basic will for some people. But then even in those will kits, they say, okay, now that you've finished, download it. You got to go make an appointment with a lawyer and make sure you sign it with someone and get an affidavit sworn, because you need that affidavit. So you're going to be retaining a lawyer or a notary or someone to swear an affidavit to do it. So you're better off getting legal advice. Because if you come to me with one of those, say, I did this online, can you just swear, I want to swear this affidavit in front of you? My answer is going to be no, because if I'm just acting on the affidavit alone, there'll be a presumption that I may have given legal advice on the contents of the will as well. And I really wasn't retained to do that. So I don't even want to do that. So that's where I think one of the arguments against using those online will kits come into play. You got to be careful with how the will is signed and getting proper affidavits. So I really caution you, it's not usually worth the money you're going to save. Okay. And I can tell you that I don't know what those will kits cost, but it's probably, a few $100s a person. It might be $200, $300, $400 a person to do it. Our basic fee for doing a will right now is $695. Okay. Now that's really for what we call a will package, because that'll include a will and 2 forms of power of attorney. There's a will applies when you die. Power of attorneys apply while you're alive, but usually they don't come into play until you're incapacitated. So one is signing authority, which is a power of attorney for property. Another one is a power of attorney for personal care, which is the ability to instruct a doctor if you're not able to. So for $695, we're doing all 3 of those documents for most people. Now, if we're doing reciprocal wills for a couple, we usually give you a break and reduce the fees a little bit for that. If you're a Sutton Summit real estate agent, we're going to give you a discount on that as well. So, come in and talk to me. But for our basic fee is that. Anyways, I can talk a little more about that later. But the point is, for the difference in what you're going to pay a lawyer to give you legal advice and get proper instructions from you and make sure the will has proper content and is signed properly, versus what you might do online to save a couple $100, it's not worth trying to save that couple $100. You're going to get yourself in trouble. And if it's not done right, you have no recourse. If I screw up doing your will, you have recourse against me and my firm and our insurance to make a claim. So, fortunately never happens, but it could happen if we screwed up in it, or any other lawyer screwed up. So you're always better off to do it through a lawyer. That's my first big piece of advice. So anyways, that's the important thing about signing a will. So let's move on here. And I want to talk about oops. Okay, just finishing up about the signing of wills. So I think I made the point already. It's really important that that affidavit stays with the will. So when we sign a will in our office, we'll get the will all signed, we'll get that affidavit signed, and we'll attach that affidavit right to the will. Now, we don't keep the original wills in our office. We give it to you. If you've signed a will, you don't leave the office with that will. Any client will leave with that original will, and we give you instructions about keeping it safe, making sure that the people you've named in it as trustees or beneficiaries know where to find the original will, because it's really important, because when you do die, you need the original documents. And those are what has to be submitted to court as part of the probate process. Okay, and I've talked last time, it's really not called probate anymore. It's called applying for a certificate of the appointment of the estate trustee. So that's really the process, but it's a lot easier to say probate, which means the same thing. But you need the original documents. They have to be submitted to the court. So it's the original will with the affidavit. A judge goes over it and eventually will approve it and give it back to you with a certificate attached saying, we've certified that that Joe Smith is now appointed as the estate trustee. And that's the document. That's just a certificate attached to the original will, but that's the document that allows Joe Smith now to have authority to deal with the assets of the estate. So let's just run through what goes in a standard will. Okay. The first thing that a will says, and this is the first point called revocation. The first thing that a will says is, I hereby revoke any other wills that I made. And the reason we do that is, for most people, you're not going to make one will in your lifetime. It's almost impossible to make a will at any point in life that's going to be good for throughout your whole lifetime. When you do a will in your 20s, it might be good for a number of years. It might be good for a number of decades. At some point, your circumstances change. You get married, you have children, you want to appoint somebody else as the trustee. You want to change the beneficiaries. You want to change the guardians. There's many, many reasons to have to change a will. It's almost impossible to make one will that's perfect for your lifetime. So when you do sign another will, after you've signed one or two or three, the first thing that any new will should say is, I hereby revoke any prior wills. So as soon as you sign a new will, September 15, 2022, that automatically terminates or revokes any wills that you may have signed previously. So upon your death, if the old will shows up, someone digs up the old will, and then you got the newer will that shows up, the newer will prevails. The old will is terminated as soon as the new will is signed. So that's the first thing that a will should say. And then the will appoints whoever you want, your personal decision, to appoint the trustee of the will. So the trustee, the common term used to be the executor or executrix of the will. Now it's called the trustee or estate trustee. It's all the same thing. So you're appointing someone whose job it is to make sure that the will gets followed. Okay, they're in a fiduciary position. They're the one that has the authority to make sure the will gets followed. Now, that doesn't have to be anybody with experience in estate. It doesn't have to be a lawyer. Most of the times it's not. That could be your family member, your spouse, your friend, whoever you personally want to look after your estate. And that person, they're appointed, they have the authority, but they'll get whatever professional help they need to administer the estate. So, they can retain a lawyer to help them through the process. They can get an accountant. They can get a financial advisor. Whatever help professional help they need, they'll obtain, but they're the one that has the authority. So in a typical husband and wife reciprocal will scenario, the husband is, we're usually suggesting that the husband appoint the wife and the wife appoint the husband. And then the other thing that you do is you always should appoint an alternate trustee in case the first person that you named dies before you or is unable to act for whatever reasons. You've named somebody else. So in my case, I might name my wife as my trustee, and in the alternate, I'm naming one of my adult children, or I can name all my adult children or something like that. You can name a friend, something like that. But it's a good idea to have somebody named as an alternate. Because again, if you don't name an alternate and the first person dies, then somebody has to apply to the court to be appointed the trustee, and you're back to that court process, which could be very expensive and time consuming. So it's good to
David, can I sorry interrupt for a quick second?
Sure.
So when you're appointing the second person, do you just equally appoint the two trustees, or is it like if one person is not able to do it, then the second one will do it?
You could do it either way. So I'll use my example. Okay. So I appoint my wife, and if my wife, but it'll say if my wife dies before me or she's unable to act, then I'm going to appoint my 3 adult children, and they act together. So now if I do that, then they have to act jointly. They have to agree on everything, and they have to do everything together. The other option I could have is just appoint one of my adult children to be it, which works as well, because that doesn't, let's say I appoint one of them, they have no more authority to receive assets of my estate than their siblings do, but they have the responsibility of making sure the will gets followed. They have a fiduciary position. So you could appoint 2 people that have to act together. A lot of times that could create an issue, because they may not, sometimes it's better to have one person in charge. You don't need 2 signatures on everything, but it's certainly an option. But that's something you would discuss in your particular situation with the lawyer when you're providing instructions, and figure out what's best for your personal family situation. So you can just name person 1 is the appointed person. If that person predeceases or is unable to act, then it's person 2, and they get the authority.
So a very quick question. Sorry, I'm interrupting a lot, but a very quick question. Regards to real estate. Say, for instance, if there are 3 power of power of attorneys on a property, and 2 are available to sign an amendment, third one is not, because there is a requirement for an amendment. Do you need all 3 to sign if there are 3 appointed power of attorneys, or can you do with 2?
It depends on the specific language in the power of attorney document. So the power of attorney document might appoint all 3, but it might say that any one of the 3 can sign documents. Or it might say we need 2 out of the 3 to sign documents, or it might say we need all 3 of them to sign the documents. So it depends on the drafting of the power of attorney document. Okay. And the same thing in a will. If you appoint more than one person as the trustee, it could say that, it might say that, usually it'll say that they have to act together jointly. They have to sign things together, which is why sometimes it's cumbersome to name more than one person as a trustee. Sometimes it's just easier if one person has the authority. Okay. So that's the appointment. And that person, again, it's their responsibility to make sure the will gets followed. Now, then a will generally says, when I die, pay any debts I might have, and my final tax return, because there's a final tax that have to be paid. So pay any taxes that are owed, any debts that are owing. And then we talk about the disposition of the estate. So who's going to get whatever the assets of the estate are? So those people are called the beneficiaries of the estate, whether it's your spouse, whether it's your children, whether you want to give money to a charity, or you want to give money to a friend, whoever's going to receive any assets of the estate, they're the beneficiary of the estate. And the will can specify who gets what. That's what the disposition of the estate is. It's who's getting what, how is everything going to be divided up, who are the beneficiaries, and how are they going to get that. So there might be a specific bequest where you might say, when I die, I want, you can do it in terms of personal property, which is things like your jewelry, paintings, your clothing, your furniture, things like that. Sometimes we usually have a clause that just couples all that stuff together and says, when I die, I want all my personal property to go to my spouse if she's alive. If not her, then it'll be divided up amongst my kids. So there's always that type of general clause. You could make something more specific, like when I die, I want my diamond ring to go to my daughter. I always caution people to be careful about that, because if you name an item specifically like that, then upon your death, there has to be a valuation done of that diamond ring, and you're going to pay a tax to the government based on the value of that diamond ring. So if it's just left with, just coupled in, it's just my clothing and my personal effects goes to my spouse, something like that, people aren't generally paying a tax on that because they generally put no value on used clothing and furniture and things like that. But when you make a specific bequest of that nature, you're going to be paying a tax to the government based on the value of that. So another type of specific bequest might be, when I die, I want my condo that I own, which is an investment condo, to go to this person. You could do something like that. There might be a reason to give that condo to somebody or something like that. Or you might say, when I die, I want X dollars to go to a particular charity, or I want X dollars to go to each of my nieces and nephews, or something like that. You could make a specific bequest like that. That's what's in there. Now, after you've made any specific bequests like that, whatever's left is called the residue of the estate. So that's after any debts and taxes are paid, after there may be a specific bequest. And maybe there is, maybe there isn't. Most people don't have something like that, but it's whatever's left becomes part of the residue of the estate. And usually the residue estate, there's a clause that deals with the residue. It says, when I die, whatever's in the residue of my estate, I want it to go to my spouse if she's alive. If she's not alive, I want it to go to my 3 kids, divided equally amongst them. Or I might not even say my 3 kids. I want to go to my kids, however many kids I might have that are alive at the time of my death. And I want it to go to them equally. Or sometimes there's particular reasons why it won't be made equally. And you say, I want, you talk about percentages. I want, this percent to go to this kid, this percent to go to another kid. Sometimes there's a good reason why it shouldn't be divided equally. And that's a real important conversation to have with a lawyer as well, because there are certain circumstances why there may not be an equal sharing amongst children, and there's various good reasons for it. There might be a breakdown in a relationship. It might be that one child has already received a lot of money that they would have received from inheritance because you've been helping them out. So this is a time to catch up for the other children that didn't get money during the lifetime. So sometimes there's some valid reasons for doing it, but it's a discussion that should be had with the lawyer and determine exactly how you're going to do that. Now, you just following through with that example, and I'll use my own situation. I have 3 adult kids. Each of the adult kids has children. I'm fortunate to have 6 grandchildren right now. So my basic will structure is, when I die, if my wife's alive, everything goes to her. If she's not alive, everything goes to my adult children, divided equally amongst them. But if one of them happens to predecease me, God forbid, and has children of their own, I want their share to go to those grandchildren. So that's part of the survival clause, or something that has to be discussed too. Like, what happens if one of those children of yours passes away, but has children of their own? And they may not have any at the time you sign the will, but they might have by the time you die. So you might want to have a provision in that says that if I do have grandchildren, I want that share to go to those grandchildren, as opposed to that share of my estate just to go to the 2 out of the 3 kids of mine that might be alive when I pass away. So those are really important things to consider and have a discussion with a lawyer and make sure it's drafted properly. Now, when you do die, if anybody that's named as a beneficiary or a potential beneficiary is going to be under the age of majority, they can't receive that. So if any of my grandchildren are going to inherit something, but they're under age of majority, which is right now in Ontario, the age of majority has always been around 18, 19, which is pretty young. So they can't legally inherit something yet, but they do inherit it, but they can't receive it. So it's got to be held in trust for them. And so we have to have a clause in the will that specifies it, that the trustee will hold that share in trust for them until they reach a certain age. And it's up to you, the person making the will, to decide what age that's going to be. It has to be at least legal age, but we generally encourage people to go to a higher age, because anybody inheriting something at age 18, they haven't seen the world yet. There's a pretty good chance they could blow that. They're not sure what to do with it. So yes, legally they can inherit it, but we generally encourage people to pick a higher age, maybe 21, 23, 25, like some other age. Let them be post university or something. We've seen the world a little bit. Now, if you do that, let's say they don't inherit until they're age 21, for example. So the trustee gets their share. The trustee is given authority in the will to use the money for their benefit until they reach age 21. So they'll give them that money or use that money for them the same way that a parent would for their food, their clothing, their education, to buy a car, to buy a condo, whatever it is, whatever the plan is. They can come to the trustee and say, hey, I need money for this. It's a good idea. The trustee has discretion to do that. So it's used for their benefit. But when they reach age 21, the trustee writes them a check. Here's your share of the will, and you're on your own. Now, the trust might continue for any other siblings that are underage, but that all has to be specified in the will. Okay, so you can decide what that age of inheritance is going to be. Now, for any of us, any of you out there that have minor children, this is the best reason to have a will. Okay, so people can fight over your assets and go to court until they spend your last dollar fighting over who should get what assets. But if you pass away and you've got children that are minors, you as a parent would want to know who's going to look after my children, who are going to be the guardians of my children. So you've got two choices. You can not do a will and leave it to everybody to run to court and try and apply to become the guardian of your children and to try and convince a judge why it's in the children's best interest, why they should be appointed. Or you can make a will and you decide during your lifetime that upon your death, who do you think is best suited to be the guardians of your children? Who do you want your children to live with? Who do you want your children to be looked after by? So again, it's a very personal right. So for anybody that has minor children, we put in a guardian clause, and you name Joe and Mary Smith to be the guardians of your children if something were to happen to you. And also, it's a good idea to name alternates in case Joe and Mary die before you or are unable to act. Who's your second choice? Okay, and if you don't have that, again, the process is somebody has to go to a court. Sometimes it's more than one party going to court saying, we should be, or I think I should be the guardian of these children. And the courts are filled with these type of applications right now, because you can take anybody, for example, and it could be if I died and I didn't mention that when my kids were minors, I'm sure at least one or more of my siblings or my wife's siblings would want to be the guardians or think they'd be the appropriate guardians. Some of our best friends might think they're appropriate guardians, but also maybe my parents at a certain point in time, or my wife's parents would be appropriate guardians. Would have been great choices, but they'd have to go to court and fight out and convince a judge who should be the best choice. So instead, my wife and I made wills, and we decided who our number one choice would be and who our number two choice would be. And because that's what a judge would ultimately want to know. What would the parents think? Who would the parents have chosen? Because their role is to make sure they act in the best interest of the children. And who's a better person to know who the guardian should be than the parents of those children? So that's number one reason to have a will. And again, you make a will, you appoint guardians, and all of a sudden the guardians you appointed, move out of town, or they move to another country, and you decide, it's not appropriate anymore. If I die, Mary and Joe Smith are no longer living in Toronto, and I really want my kids to grow up in Toronto. So I got to change my will. So then you change your will. It's not a big deal to change your will. So you change it and you name somebody else as the guardians. But an important thing to protect your minor children by naming guardians. Now, when we do wills, we put in some provisions to give the trustees broad powers. And part of that is we don't know what the assets are going to be that are going to form part of the estate. It might be real estate, it might be stocks and bonds, there might be assets in a RIF or something like that. It could be all kinds of different assets. So we put in specific clauses that give broad powers to the trustee to deal with different types of assets, and to deal with the accountant, and to deal with filing tax returns and things like that. Because you don't want to handcuff the trustee. You're appointing somebody that you're going to trust as your trustee to act in your best interests and the interests of your estate. So you want to make sure they're not handcuffed and they're given proper powers. And some of these will kits and things online that you see are really short on describing those powers properly. And I even see it from wills done by lawyers. You know, like our typical will, just to give you an example, is probably 12 to 15 pages long. And most of the stuff that I'm talking to you about now are in the first 3 or 4 pages. And then there's a whole bunch of pages that are just broad powers to the trustee. And sometimes we see wills that are 3 or 4 pages long done by lawyers, and they just don't have all these things in there. And people get in trouble trying to deal with the estate because they're handcuffed because they don't have the right clauses in there. The next thing I want to just tell you about that standard in wills that we do is this next point that says exclusions from net family property. And what this is a Family Law Act thing. And the basic principle under the Family Law Act, when people accumulate assets, family assets, then what happens when there's a divorce? So I'm just going to use my family as an example. I've got a daughter. She's been married. Everything is fine. Everything is great. They're building a life together. They own a home. They have joint bank accounts. Everything is fine. Eventually, my daughter is going to be she is named as a beneficiary of my estate. So if she inherits something from me, and then her marriage breaks down, does my son-in-law, who I've always loved, and he's a great guy, and I hate using an example, but now I hate him because they're divorcing. So do I want him to share in my inheritance or not? So there is a way to try and prevent that, and that's by having a clause in the will saying that whatever my daughter inherits is intended to be hers and not to become part of her assets, her family assets, so that if her marriage breaks down, that the inheritance will remain hers and it won't be split 50-50 with her husband. So we always want to have that type of clause in there to try and protect your children as best as you can. Now, if my daughter happens to inherit from me and then she chooses to use her inheritance and just mingles it and it becomes part of her family assets, and that goes on for a period of time, and you can no longer trace the inheritance. They used it to pay down their mortgage, or they used it to buy their matrimonial home, and time goes on, and she chose to use it as a family asset, then the marriage breaks down. She may not be able to succeed in saying, hey, that was my inheritance, and that should be excluded, because a judge might say, yeah, but you chose to make it part of your family assets, and you lived that way and you did that way, so it became part of your family assets, so therefore it's no longer traceable and it can't be excluded anymore. But it's the best we can do is to put a clause in there that this is the intention. Okay? Is there a question, Sabiha?
Yeah, David, what if the children are not married at the time that you made the will? You put that clause in there,
Still put it in. Yep.
right?
Yep. Still put it in. It's whatever my children inherit, the intention is that that'll remain their inheritance and not the inheritance, and they don't have to share it with any spouse, current, future spouse, doesn't matter. Okay. Now, the other thing, next point I want to just touch on briefly is funeral instructions. A lot of times in wills, people put funeral instructions, which would be something like, I want to be buried, or I want to be cremated, or I don't want to be buried, or I don't want to be cremated, or something to that effect. Okay. Now, there's no problem putting that in a will, but I always tell people, if you really have strong feelings about that, it doesn't matter if you put it in the will or not, because what happens in practical terms, when people die, they're grieving, they're dealing with it. A lot of times people don't look at the will for quite a period of time after someone dies, or they haven't located it, or they haven't found it. So if you really have a strong feeling about burial or cremation or something, make sure your inner circle of family and friends know about that, and they'll deal with it appropriately, because it's really bad if they don't know about that, and then you're cremated, and 3 weeks later someone goes and finds the will and it says, I want to be buried and not cremated, and you're already in a jar. And I don't mean to make light of it, but I've seen that happen. So so I just caution you, you can certainly put that in a will, but you have to make sure that your inner circle of friends and family know how you'd want to be treated upon your death. Okay. Same thing with donation of body organs. You know, it might say something in the will, but sometimes people don't look at the will, or don't find the will for a while. So if you've got a real strong position about that you want, you know, to make a donation, you know, make sure that you're signing those forms and people know where to find those donation forms, and that's available, readily available, and people know about it, that's you know, that you have a strong position on it, because again, they may not find the will or get to it till way after. Okay. Now,
David, can I go back
compensation.
and ask you a question about
Sure.
your when you said about the joint tenancy, you know, the word saying joint means that it's equally shared, equally owned,
Yep.
and when somebody passes away, the other person inherits the full um, property or whatever it may be.
Yep.
Just a quick question on that. So if, for instance, you want to specify that there should be some shares that go to your children out of it, that cannot be done with a joint tenancy. Is that right?
No, no. You could add your children to title to a property as joint tenants with you. So upon your death, you know, if you own your home, um, you can say, you can add your children, as we talked about this a little bit last time, you can add your children to it. So upon your death, they become the owners by right of survivorship, but you've got to be very careful in doing that, because you lose control of
Right.
dealing
No,
with that
I was
property.
saying that if you own a property in joint tenancy with a spouse, is there any which way to specify that if you die, some portion of that property should go to your children, or is it just automatically?
You do that in a will.
Yeah, you can.
The will is the document that you do that in.
Okay, so
Okay.
it's a joint tenancy home owned with your husband, but if in the will it specifies that certain part of the property, if you die, the husband's still alive, you can still specify that a certain part of that property is going to go to your kids.
Well, no, if you held it as joint tenants, you and, you know, between spouses, and the first spouse dies, it goes to the other one.
Oh
Now,
yeah, so you
you
can't.
could sign, you know, have documents signed. It gets a little more complicated, saying, um, and we do this also. It's sort of, we need a trust document signed at the same time, and we do that sometimes when we do add. Let's say you have an elderly parent, and you're adding adult children to the title as joint tenants, but the intention is, like, you just want to avoid. You're doing it to avoid paying the government a tax on the real estate, and the value of that real estate. But the intention is that, yes, they're going to acquire it as a joint tenant, but they're really supposed to be holding that property in trust and dealing with the value of that property in accordance with your will. So there is a way to tie that in together. It gets a little more complicated, but it certainly can be done. Okay. So the last point I think I want to make on what goes in a standard will, there's a compensation clause, which does allow a trustee to be compensated for their time and effort to be a trustee. Most of the time we do wills, that doesn't come into play. It's usually you're appointing a spouse, or you're appointing your children, or you know, they're usually beneficiaries under the estate anyways. Usually they're not looking for compensation. Unfortunately, they're spending a lot of time to deal with this. But they do have a right to be compensated on a reasonable basis for the time that they spend administering the estate. So that's usually a clause that goes into a will as well, although it's not always used, but it's there. Now, one of the real important reasons for a lawyer to be involved in doing a will instead of these will kits, et cetera, is one of the main functions the lawyer has to do is we have to assess the capacity of the person signing the will to sign the will. Okay, did they understand, if we're doing a will in English, did they understand English enough? Was it translated properly? If they don't understand English, do we have a translator there? Did they clearly understand what they're signing? Are they of sound mind? Were they capable of signing the will? Because they, you know, like if we get the impression, and we're not professionals to assess it, but if we think there's dementia or Alzheimer's or something like that, and they don't really understand what they're signing, then we won't let them sign the will, because you have to understand what you're signing. You have to have sound mind. You also are not supposed to be under the influence of any other person. So if someone comes to us, an elderly parent, just use this as an example, comes to us with an adult child who's one of 4 adult children. And they're saying, my dad needs, he's 95 years old. We have to update his will. His old will says, when he dies, everything gets divided amongst the 4 children, but his relationship with the other 3 has broken down. He doesn't talk to them. They don't come and visit him. And he wants to give everything to me now. So we want a new will that everything goes to me and not to my siblings. So part of my rule is I got to assess, does this 95-year-old person really understand what he's doing? Does he have sound mind to make this? And is he under the influence of this one child to the detriment of the other children? And if we get any smell of the possibility that there is undue influence, we won't let them sign a will, because that will is surely going to be contested by the other 3 children. Okay, so anytime we're asked to do in a will to not divide assets equally amongst children, we got to be asking the right questions, and we got to be convinced that there's a good reason for doing this. Otherwise, we sort of know as lawyers, this will, when that person dies, this will is going to be contested. Okay, so if it's going to be contested, we want to have notes in our file, and we want to have proper conversations. We want to make sure that whoever signed the will understood exactly what they're signing, and they were not there was no undue influence. So we will even ask, if that was the scenario, we would ask that adult child to not be in the room, and we have a conversation directly with that person saying, what's the story here? Okay, with your other children. And if we're not convinced, we're not going to do it. Okay, it's a really important thing. Now, you can't do that online when you're doing a will kit. You can't have that type of conversation. And that's an important thing. Now, I want to try and keep this to an hour and then take some questions. The last thing I really want to talk to you about is a dual will structure. So one of the things, when we send out a questionnaire to people, and that's how we start the process, by the way, when someone says, I'm interested in doing a will, we'll send you a fill in the blank type of questionnaire to give us some basic information on you and who to gather information of who the potential trustees are, beneficiaries, what the assets are, things like that, all the things we've been talking about. And we have another form that we use for powers of attorney as well, basic questionnaire. One of the things we want to ask you is, do you own any shares in private corporations? Like, do you have a holding company, or your shares in your PREC as a real estate agent? Because there is a mechanism in Ontario to keep the value of those private corporations out of your will. So let's say you do have a holding corporation, or you're a shareholder in a PREC, and you only have one will. So if it was me, my will would say, when I die, everything goes to my wife. So that would include shares that I own in a holding corporation. So now the value of that holding corporation has to be assessed, and we have to pay a tax to the government on the value of that corporation in order for my wife to get those shares transferred to her. So there is a way in Ontario, by having a dual will structure. You have 2 wills. One will deals with private shares that you own in a corporation, and the other will deals with everything else. So upon your death, it's only the primary will that deals with everything else. If that has to go to get probated, that's the will that gets probated. But when we do that, I can exclude the value of the shares that I own in the private corporation, because that's covered by my secondary will. So the 2 wills might mirror each other. And using me as an example, my will says, when I die, everything I own other than the private shares in the corporation goes to my wife. Now, that might have to be probated, and whatever assets I have that were in my name alone are part of the probate process, but not the shares that I own in the private corporation, because I have a second will that says, when I die, any shares that I own in any private corporations I own goes to my wife. So that happens automatically. Now, she's the shareholder. She can sign documents as a shareholder to appoint herself as the officer and director of the corporation. She can have signing authority. She can deal with those corporations herself without going through the probate process. Okay, so it saves you a lot of time and a lot of money to do that. So that's one of the questions that we ask. Do you own shares in private corporations? So it's not shares in publicly traded companies. It's not stocks and publicly traded companies. It's just, this is for your private corporations. And if you do, we're going to do 2 wills for you. And we'll do 2 wills for your wife as well, because, or your spouse, because even if they don't own shares today, they might own shares upon your death. So if you have a PREC, for example, or a holding corporation, and you might be the only shareholder right now, but upon your death, you want it to go to your spouse, or you want it to go to your adult children. So they should have a dual will as well, because at some point in time, they might acquire shares in a private corporation. So obviously, if we're doing a dual will, there's additional costs involved because we're doing extra documents, but it's not, I don't even know what our current fee is. It's not the full fee that you're doing. We're already doing 1 will, and we're going to do the dual will. So we're adding a few $100s to do that, but it's an important thing. So, but the dual will basically excludes certain types of property. The most common one is the shares in corporations. Okay, but there's ways to deal with other assets, exclude that from the estate and the probate process, and that's what we've sort of structured here. Just give you information on it, because it could be insurance proceeds. We talked about that's a good way you want to exclude that by naming beneficiaries. We want to have property held as joint tenants, so we have that right of survivorship. Real estate that's outside of Ontario, we want to avoid having probate issues with that. So a separate will could deal with that type of thing. In our firm, we're only dealing with wills in Ontario. We're not going to do wills that apply in other jurisdictions. So just know that as well. There are ways of doing international wills. There are more sophisticated wills that we will not do in our office, but we can certainly give you direction on doing that. But when you're doing this dual will structure, can be very important for a lot of you who do have holding corporations for investment purposes or otherwise. And if you have a PREC, it's a good idea to have that as well. So again, if you have that, you're not going to pay the estate administration tax on the value of the corporations. So, and I think we've give you an example in here. So if a corporation has a $500,000 of assets, by having the secondary will in place that just deals with the corporate assets, there's a tax saving of $7,000. If you had a $2 million in assets in your corporation, the tax savings would be $29,500. So why not do it for a couple $100 extra when you're doing your wills? You do the dual wills at that time. And we call one of them the primary will, the other one's called a secondary will. The primary will deals with all the assets not covered by the secondary will, and the secondary will is usually just covering these private shares in a corporation. So that's basically the process here. So, and again, if you have a spouse, I would encourage you to do that. And even if the spouse doesn't own shares, she could inherit it. So I'm sort of repeating myself. If she's going to inherit shares, potentially at some point in time, good for her to have that secondary will as well. The last thing I want to touch on before I open up for questions, and I've already talked about it before, the difference between being a power of attorney and a estate trustee. Power of attorneys are appointed, they apply while you're alive. They might apply while you're alive, but incapacitated, or it could be general power of attorney that can apply even if you're not incapacitated. Those are separate documents. We always have those discussions with clients and determine what's the appropriate type of power of attorney documents for you to have. So being appointed as a power of attorney is different from being appointed as a state trustee. A state trustee, you're only appointed, it only comes into effect once somebody dies. And as soon as somebody dies, the will applies. The estate trustee is the one with the power, and the power of attorneys are no longer valid. So if someone dies, you can't try and run to the bank and use a power of attorney and say, oh, I want to transfer the assets. I'm the power of attorney. That document is no longer valid as soon as you pass away. Now, I mentioned there's different types of power of attorney. There's the power of attorney for property, which is the authority to sign documents on someone's behalf. Very powerful document. It can be limited into what you can sign, or it can be a very general document. It could say you only have that authority if someone's incapacitated, or it could say you have the authority at any point in time. And that's the form that's sometimes used when you're dealing with elderly parents, for example, that want you to step in and help them out to manage their affairs. So they might want a general power of appointment, or they might say, no, it's only if I become incapacitated that you can use this. Very powerful document. The only thing you can't do, like I mentioned before, is sign a will for somebody else. The power of attorney for personal care is the one where you instruct a doctor to, you're giving somebody else the authority to instruct a doctor for your personal care. So if I'm in a coma and I can't instruct a doctor to do either procedure A or procedure B, whoever I've appointed as my power of attorney for personal care has that authority to instruct a doctor as to how to deal with me. If I recover, I'm back to doing it on my own. But if I'm incapacitated and somebody has to make that type of decision, there's a document for it. And again, in the absence of having that document, somebody has to run to court to be appointed as that power of attorney. So instead of spending, $695 as part of our package, it's included in that, or if we just did a power of attorney alone, it might be $250 or $300 or something like that. They're going to spend thousands of dollars going to court to get an appointment. So it's not an expensive process. Everybody should have a will. Everybody should have power of attorneys. And you can't make a perfect one, you do it. I always tell people, think of it, if I die today, how do I protect myself? If I become incapacitated today, how do I protect myself and my family? If you sign the documents the best you can today, if that has to be changed 6 months from now, 6 years from now, or 60 years from now, you'll change it whenever it has to be changed. But protect yourself, get it done. Protect yourself, your family members, protect your clients. And I think I've already mentioned the difference between a general and a specific. General could be used at any time. A specific power of attorney might be, some of you are familiar with it. I'm gonna be out of town. So I want to, and my sale is closing. So I want to appoint somebody to have signing authority to sign all the sale documents for the sale of my condo. That's an example of a specific power of attorney. These days, we don't even use that very often because with our new systems and technology, even if someone's going to be out of town, as long as they have access to a computer, we can generally get things signed from wherever they are in the world. So a lot of times we don't do specific powers of attorneys as often as we used to, but that's just an example of that. And then a continuing power of attorney is the type that can be used at any time, whether you can use it if you're incapacitated or not incapacitated. There's provisions in that. Important that these things get drafted properly. Anyway, sorry for talking so fast. I'm always trying to get a lot of material in a short period of time, but I want to respect your time and trying to keep it as close as I could to an hour. And I'll stay as long as we want to answer any questions that you might have.
So David, I think along the lines of what my question was, Abu's just put that in on another flip is because I think we're talking about when there's the spouse, the children are not from the same spouses, and if you have ownership in a property and it's in joint tenancy, and you somehow want part of that inheritance to go to your children as well. So Abu's put in that on death of one person in joint tenancy ownership, if the survivor remarries and ends up having kids with the new partner, how do you ensure that your share of the property is eventually inherited only by your biological children?
Yeah, that's a great question. And it's a bit of a complicated answer because there is a way to do it. There's a couple of different ways to do it, but it's sometimes it's not so easy. So if we just break it down, let's just say husband and wife, and they sign reciprocal wills. When I die, everything goes to my wife. My wife dies, everything goes to me. If we're alive, if not, it goes to my children. So let's say I die first, because that's the way it works. So now my wife inherits everything from me, and our intention is, and in good faith, we sign these wills together. And our intention is that upon her death, everything's going to go to my 3 kids, divided equally amongst them. So then the question is, well, what if she remarries? Well, or what if she changes her wills? So it applies in both ways, because let's just say, for example, my wife has a falling out with one of my adult kids, and she decides to just forget about getting remarried. She just decides on her own to change her will, and she wants to cut out or make an unequal distribution. So I'm not happy with that, but too bad for me, I already died, so I can't do anything about it. So if my will just says everything goes to her, then once she inherits it, it's up to her. And in my situation, I trust her judgment and what she's going to do, and she's going to look after my kids. Now, if you're not as confident, in your spouse, or you're worried about, well, your spouse might remarry, there might be different pressure on her. How do I make sure it's going to get to my adult children? So the different way you could do it, you could say that when I die, anything I own, I want to go to my wife if she's alive, and she can use it and keep it and use it for, I'm giving her what's called a life interest. She can use it during her lifetime, but upon her death, whatever's left over goes to my kids. So that's one way of trying to deal with it. Now, that's not foolproof either, because in theory, when she inherits, she can use it all up. She could spend every last dollar, and then upon her death, there's nothing for my kids to inherit. So I can't protect against that. So a lot of things aren't foolproof. The other way to do it would be to say, okay, when I die, I want a certain percentage to go to my spouse, and I want a certain percentage to go to my children. So that goes directly from me under my will. So that's certainly possible, and depends on the type of assets and estate that you have. But for a lot of people, that could be problematic too, because there's certain assets that aren't going to be liquidated necessarily upon your death. So, do you want if you're, depends what stage in life you are. And these are complicated questions. So I don't mean for this to sound evasive in any way, because there are different ways to try and figure out how to do this appropriately. But it's not all black and white. There's a lot of gray, and it depends on the fact situations, depends on the age of the people that are making the will, depends on the age of the adult children. It depends on the likelihood of remarriage. It depends on a whole number of factors, the relationships. So sometimes it makes sense to have, certain assets go to a spouse and other assets go to adult children right away. But you also have to consider is, what effect is that going to leave on my spouse, and how old is she, and what's her life expectancy at that point in time? If I'm taking away assets that she needs to live on in order to get things to my children, is that a good way to do it? For some people, that might be a good way to do it, because you might know that your adult children are going to inherit things, and they're going to look after their mother and make sure that she's looked after. So a lot of that depends on family situations, but there are a few different things that can be considered, and it gets complicated when you get into those situations. But we have to look at all the facts and try and tailor make something for the right fact situation.
I think David and Abu and anybody else my thought, David, correct me if I'm wrong, is if you have children of your own, and then you remarry, and then you end up buying a property with your spouse, and it may not be a principal residence, it might be an investment property. I think the best way to go about would be to buy it in tenancy in common rather than joint tenancy. And then you can leave your share of the property to your children in your will. Is that
Yes.
right?
Yeah, no, that's a good point, because if you have it as joint tenancy, the person then dies, and their share, whether it's 50%, whatever percentages, would go to their estate, and then their will applies, and that would get to their children. If they own that property as joint tenants with the second spouse and they die, then that interest would go to that second spouse. So that's a good point. So that's why I'm saying we have to look at the actual
Right.
fact situations. And again, why it's almost impossible to make a perfect will and do this all perfectly. It's going to last throughout your lifetime, because facts and circumstances change.
Change.
And
Mhm.
the other part of the question, I think, was what happens if there's children of a second marriage too, and they're not your biological children. So the will basically, the basic will, it says, if I die, it goes to my wife. If not my wife, it goes to my children. It usually specifies in the will that we're talking about my biological children, or any children that I've legally adopted that I want to share in that. And you can describe it differently, because it might describe it, no, it's only going to be my blood children, and it's not going to be any children or children of any subsequent marriages or things like that. So you can be specific in that, to protect that way. And
Mhm.
again, when someone does remarry, that's a good time for that person to be reviewing what their old will says, because it's probably they should be updating that will. And they might want to specify that, hey, these are my children from the first marriage, and they're supposed to inherit certain things from that first marriage, and maybe there's some other kids from a second marriage, and maybe they share differently. And that can all be described in a will, but that's a good time to do a new will.
Mhm.
And
Kelly has asked a question, but I think, Kelly, you missed the first part of it. She's asking the difference between an executor and a trustee of a will. So
It's the same
there is
thing.
none. Yeah.
It's the same thing. Old terminology used to refer to everybody as the executor or executrix of the will. Under the current act, it's really referred to as the trustee or estate trustee. Sometimes you hear it referred to as the personal representative. But the correct term right now is the trustee or estate trustee, but it all means the same thing.
and David, I had a question, like based on Sabiha's proposal about buying investment property in tenancy in common, that way. So what if somebody buys the investment properties under a corporation, how the inheritance of that works out for the corporation, like how the will things will turn out here, like can there be a will for the corporation in such a way so that
Sorry, I'm not hearing you really clearly. I heard you, maybe you could speak up a little bit. I heard you saying, but buying an investment through a corporation.
yes,
And then what?
and then like how do ensure that like again on the same line, like now that it's under a corporation and in the corporation, like both the spouses are actually the signing authority. Now on death of one person, automatically everything goes to the second person who is the surviving person, signing authority of the corporation, right? Now if
Well, no, it doesn't automatically go to the other shareholder, like to the spouse, unless there's a will that says upon my death. Like the shares that you own in a corporation are just assets. It's no different than I have a bank account. So if I have a bank account, then I have to say in my will, whatever, that's an asset of my estate. So whatever's in my bank account goes to my spouse. Whatever shares I own in a corporation go to my spouse. If the will says that, excuse me, then the spouse acquires those shares. The reason I suggest doing the dual wills is because if you don't do the dual wills, those shares have value. It's whatever, if that corporation is worth $1 million, then you have to include that $1 million value in the probate process, and you pay the government a fee on the value of that corporation. If you had a secondary will that just deals with the shares in the corporation, still says the same thing. When I die, the shares go to my spouse. The value of the corporation does not have to be included in a probate process. The spouse gets those shares, and she's the signing authority for the corporation. You do that outside the probate process.
all right, and can there be a way to, like, other than the signing authority to the spouse, like the previous question that I had asked, like that you wanted some portion of it to go to your children from that corporation and some portion of it to your wife because you.
Yeah, same thing. You can, the will can say that when I die, I want a certain amount of shares to go to my spouse and I want other shares to go to my children. The will can specify that. Okay. And because your children might inherit shares in a private corporation, they may not own shares right now, but at some point they might inherit it. It's a good idea for those children, and I'm assuming like adult children, like old enough to make a will, they should have dual wills too. Even though they may not have a holding corporation right now, they might inherit shares in a corporation. So if they don't have a dual will now, as soon as they do inherit those shares, they should get another will done. They should get their wills redone so that they have the dual wills.
All right, thank you.
Any questions, guys?
Yeah, David, I've got a quick question for you. So I get the entire difference between power of attorney versus trustee and what they're used for. One is when you're still alive, the other is for after death. But what would you say, and sorry if I missed this along the way, what would you say is the greatest risk to the will holder if you don't assign a trustee after death?
Greatest risk to the will holder, you mean just the person dies without a will?
Well, no, sorry. Okay, so there is a will, but what's the greatest risk if there isn't a trustee assigned? So let's say that there's 3 children, they're the beneficiary. It's written into the will currently, they're the beneficiaries of the property, but there isn't a trustee assigned. So what could
I've never seen a will drafted that doesn't name a trustee.
Okay, so there will be a trust. So the trustees would either be, could be all 3 children, could be the wife. Okay.
Yep. It could, yeah. You know, sometimes, you know, people, you know, for most of us, they're going to name somebody who's a beneficiary as their trustee as well. It might be a spouse, it might be their children, it might be all of their children, it might be one of their children. It's usually somebody close to the family for most of us. You know, there are certain wills and estate planning that gets much more sophisticated, and sometimes people don't have anybody to appoint, or they may appoint an alternate. They might appoint a trust company, you know, one of the financial institutions, and they have someone appointed as a trustee. And then for sure, you're going to be paying them a lot of fees. They have to be compensated to have that rule. But for most of us, we're naming somebody who's, you know, who's part of, you know, usually they're also a beneficiary, but they're wearing 2 different hats. The trustee has a fiduciary responsibility just to make sure the will gets followed. If they happen to be a beneficiary, then they'll share in the estate, whatever the will says, but they can't prefer themselves over other beneficiaries. And if they do, the other beneficiaries will challenge them on that. And they have the right to take them to court saying, no, you know, you can't take a preferential share. It's supposed to be all of us. So, you know, there's a lot of estate litigation that deals with those type of issues too. But every will has to appoint a trustee. There's, you know, that's the whole purpose of having a will, to appoint somebody who's responsible to administer the estate.
Okay, that makes a lot of sense, because I think I was getting the trustees' power and the beneficiaries' benefits kind of confused. So they're 2 separate things.
2 different things. You can be both a trustee and a beneficiary. In most wills, people are both trustees and beneficiaries. You know, we don't do very many wills for us common folks where the trustee is someone that's completely unrelated to the family or the person dying and is acting only as a trustee. That only generally comes up with people that have, you know, 0 family, 0 close friends, and, you know, and they got to appoint some institutional type of trustee for it. But usually it's somebody who's also a beneficiary.
Right.
John, I'll just, if I can just, you know, add to that is, I know, I mean, there's a few people here that are younger couples. So when I was on my own, and I had 2 fairly small children. I actually, my brother was the trustee on my will, but he was not the beneficiary. But I did assign a small, you know, token to him that for actually administrating it, because my kids were very, very young at that time, right? Hadi and Alicia were 2 and 4 years old. So that's also something that can happen. I mean, I wasn't rich at all, but I did have a trustee, but he was not the beneficiary of my will. Now I need to, David, come and see you. Change my will around, because it's, you know, it's become kind of old and not applicable.
That's a good point. The other point I make too is, you know, you're appointing someone as the trustee. When you have small children, you're also appointing someone as the guardian. Sometimes it's the same person that, you know, the trustee is responsible for the assets of the estate. The guardian is responsible for looking after the children. Sometimes it's the same person. Sometimes people want to have different people. No, I want my kids to live with my brother or something, you know, because I want him to be the guardian, but I want my close friend who happens to, you know, to know how I think more. I want him to be the trustee, or I want a different sibling to be the trustee, and somebody else to look after the financial side of the estate as opposed to looking after the kids. Now, the guardian would then have to go to the estate trustee sometimes to get money to look after the kids. Sometimes people like that layer and have a differentiation there. And sometimes the situation is good for the trustee and the guardian to be the same person. But again, these things depend on your particular fact situation, and those are the type of discussions that you have with the lawyer dealing with it. And you can't
it's quite complicated, guys. Yeah, I would really advise for you. I mean, there's so many different, like when David, I was getting my will made, my sisters were both in US, and I would have, I wanted them to be the guardian of my children, whereas my brother to be, and then I was told that, if you have actually a trustee who's not a Canadian citizen and resident, then they have to put as much money down till the disbursement. So it's so complicated. So, I would really advise everybody not to go by the pre-printed wills out there. Selva's asked a question where she says, "Sorry, I missed this. What's the greatest risk if you die without a will?"
Okay. If you die without a will, somebody has to apply to the court to become the estate trustee without a will. There could be more than one person that's applying to become the estate trustee. So they have to have a court battle and convince a judge as to who should be appointed. So that's the first expensive, time-consuming process. Now you've got somebody appointed to look after the estate. Then the second thing is who's going to share in the estate. So everybody can be applying to the court saying, I should be a beneficiary. It could be children, it could be grandchildren, it could be friends, it could be cousins, it could be people from past marriages. You never know who's going to apply saying, I think I'm entitled to share in the estate. And they got to go to court and convince a judge as to who should share and who should not share and what percentage should go to each person and everything. So they're going to spend a lot of money in court fighting that out. So it's very time consuming, it's very costly. If you have a will, you decide who's your estate trustee, you decide who your beneficiaries are. Way less expensive, and your wishes are what governs the process.
All right. Okay, I think amazing session. Guys, reach out to Korman's if this is not complicated enough. I feel like we're all feeling it right now. So, but yeah, I mean, this is really, really good information, David. Thank you so much for the session.
Okay, my pleasure. Last point I want to make, Sabiha, and I know you sit through an hour and a half of this, and it sounds like there's a lot of issues, a lot of complications. But the process of doing a will, if you really think about it, it's really simple. For most people, there's very few questions that we need answered. Who's going to be your estate trustee? Who's going to be the alternate? Who's going to be the guardian? Who's the alternate guardian? And then who gets it upon your death? Like it boils down to that. The rest of it, there's all these clauses that go in there, but basically those are the most important questions. It's not that complicated. It's really easy to get that will done. And then again, like I've said previously, if you have to change it at some point in time, you get it changed, and that's not a difficult process either. So although there's a lot of issues that could come up, for most people, there's certain basic questions to get answered. It's not that common. Get it done. As your circumstances and life circumstances change, then you look at it again and you change it. Okay. So I encourage all of you to do it and reach out if you have further questions. Thanks for having me on today.
Thank you.
Thanks very much, Dave.
Okay.